Hey everybody, so I wanted to take about 10 minutes at least to go over this court document that was filed on October 19th of 2016. That's about 2 weeks before Heritage shut down and left a note on the door stating that they just ran out of cash and couldn't continue their business anymore. So, with that being said, coincidentally 2 weeks beforehand, the court document comes out talking about them changing grades and attendance. So I went through, and as you can see, I kind of just highlighted stuff that I felt that was really relevant and I think people should hear. So, like I said, let me take the next 10 minutes, get through this, and then we'll go from there. Okay? There's so many papers. Miller and Silman filed a qui tam false claim suit against Heritage College, alleging it fraudulently induced the Department of Education to provide funds by falsely promising to keep accurate student records. Heritage, a for-profit college, signed a program participation agreement with the Department of Education to participate in programs under Title IV of the Higher Education Act of 1965. Around 97% of Heritage students received Title IV aid, accounting for about 90% of gross tuition. From 2009 to 2012, the Department of Education disbursed $32,817,727 to Heritage. The Program Participation Agreement obligates Heritage to establish and maintain such administrative and fiscal procedures and records as may be necessary to ensure proper and efficient administration of funds. To be eligible for funds, a student must make satisfactory progress. Satisfactory progress is measured by cumulative grade point average. Refunds to the Department of Education may be due when a student withdraws, depending on how much of the program the student completed. Realtors, both former Heritage employees, claim that Heritage altered grades and attendance records from 2006 to 2012 to ensure students made satisfactory progress and to avoid refunds, thereby maximizing Title IV funds. Miller saw an administrator increase student grades without instructor knowledge or consent, erasing the grades in the paper grade book and replacing them. She saw administrators alter attendance records to mark absent students as present. At meetings in 2009 and 2010, Miller heard administrators discuss keeping students at Heritage long enough to get all Title IV funds possible. 2 other program managers testified that administrators ordered them to go through instructor grade books and change failing grades to passing. For the purpose of summary judgment, Heritage does not dispute that it altered records. In December 2010, Realtors complained to Heritage about this and other alleged misconduct. Realtors filed a qui tam FCA action alleging numerous theories of FCA liability. The federal government declined to intervene. The court granted summary judgment to Heritage on all claims. Realtors appeal on the theory of FCA liability, fraudulent inducement. Realtors claim that Heritage committed fraudulent inducement by signing the PPA without intending to maintain records as may be necessary to ensure proper and efficient administration of funds. The district court held that Heritage did not promise to keep perfect records, and any promise was not material to the disbursement of funds. At issue is whether Heritage made a knowingly false statement and whether it was material. Realtors claim that Heritage falsely stated that it would keep accurate student records. Heritage argues that the PPA does not require the maintenance of these specific grading and attendance records. For a statement to be knowingly false, a person must have actual knowledge of the information or act in deliberate ignorance or reckless disregard of the truth or falsity of the information. To demonstrate this promise was false, it is not enough to show that Heritage did not comply with the PPA. Realtors must show that Heritage, when signing the PPA, knew accurate grades and attendance records were required and that Heritage intended not to maintain those records. Realtors point to the following evidence of Heritage's pre-PPA knowledge and intent. First, they note that Heritage's own policy states it is vitally important that the school maintain accurate student records. We are responsible to the state, the accrediting agency, the U.S. Department of Education. Student records must be complete and accurate, and we must be able to create and keep records of all students' enrollment activities, academic achievement, and financial activities. And that was pulled straight from the Student Records Operation Manual number 3 in 2007. Second, realtors highlight a pattern of record falsification. Realtors have presented evidence of numerous instances where Heritage administrators changed a student's failing grade to a passing grade without the instructor's knowledge and consent, or instructed a teacher to change the failing grade to passing grade. Student Danielle Kimball declared that her attendance record reflects false hours throughout 2008 and 2009. Student Lonnie T. Black swore that his transcript had passing grades for multiple classes that he had failed, and that he was often given attendance for days he was not even in class. Miller testified that in 2008 and 2009 she saw more than 50 instances of administrators adding attendance for absent students by writing on the roster before it was electronically recorded. Realtors also call attention to records falsified in 2009 to 2012 after the PPA was signed. Miller witnessed Heritage's new director of education erase the grades of an entire class from the instructor's paper gradebook and replace them. Program manager Shauna Hopp recalled multiple meetings where Heritage administrators told all program managers to go through instructor gradebooks and change failing grades to passing. Hopp changed several students' grades by erasing and replacing them in the paper book and saw an administrator multiple times do the same. Program manager Tess Graham resigned because twice she was ordered to go through the instructor grade books and increase grades below 70%. Glover identified several students whose grades were increased without their knowledge, and Tarita Smith said an administrator routinely asked her to increase grades from failing to passing, which she did a couple of times. Realtors argue that pre- and post-PPA pattern of altered records indicates Heritage intended to manipulate Title IV funding. Heritage denies this intent but offers no other reason for changing the record. Third, realtors point to evidence that Heritage aims to maximize its Title IV funding. One instructor testified that between September 2007 and September 2009, Heritage administrators made it clear in a couple of staff meetings that basically they were receiving funds from the federal government for every butt that was in the seat, and it was very important that we keep butts in the seat. In 2009 and 2010, Miller heard administrators discuss the importance of retaining students as long as possible in order to receive the maximum amount of federal student loan funds, and that the goal was to keep students long enough to grab the entire amount of tuition paid for by their federal student loan funds. Based on this evidence, a reasonable jury could find that Heritage knew it had to keep accurate grades and attendance records and intended not to do so. At summary judgment, this court examines whether there is a genuine issue of material fact. It does not weigh the evidence or decide credibility. There is a dispute of material fact whether when signing the PPA, Heritage intended to manipulate its grades and records in order to impede the proper administration of funds, and thus whether Heritage made a false promise to the Department of Education. Heritage, for the purpose of this appeal, does not dispute that it falsified these records. It does not argue that it acted in accordance with the legitimate grade and attendance policies, or only falsified records that could not impact Title IV funding. Because there is a dispute of material fact about how Heritage understood its obligations and whether it intended to comply with the PPA, the district court erred in granting summary judgment. Heritage asserts that the falsified grade and attendance records did not cause improper disbursement or retention of the Title IV funds, and thus were not material to government funding decisions. The district court agreed that any false statement by Heritage about record keeping was not material. A false statement or record is material for FCA purposes if either 1, a reasonable person would likely attach importance to it, or 2, the defendant knew or should have known that the government would attach importance to it. Materiality depends on whether Heritage's promise to maintain accurate grade and attendance records influenced the government's decision to enter into its relationship with Heritage. Significance of the requirement in the government's acts show that the record-keeping promise was material. Heritage promised to maintain such records as may be necessary to ensure proper and efficient administration of funds. A reasonable person would attach importance to a promise to do what is necessary to ensure funds go where they are supposed to go. The government's acts confirm that it cares about the promise at issue. The Department of Education relies on school-maintained records to monitor regulatory compliance. When colleges do not adhere to this promise, there are consequences. As realtors argue and Heritage admits for purposes of summary judgment, the Department of Education sometimes terminates otherwise eligible institutions for falsifying student attendance grades and records. The government's reliance on colleges' accurate record-keeping shows the importance of Heritage's initial promise to maintain accurate records. For purposes of summary judgment, Heritage's promise to keep accurate records was material. The court erred in ruling that Heritage's promise was not material to the government's disbursement decision. So, let me just recap what just happened. Okay, I took the court document from the United States Court of Appeals that was filed October 19th, went through and highlighted basically certain sentences that I thought everybody should hear. I read them to you verbatim, best to my ability, in order. I know they're in order, so if you go to the court document, look at it, you're going to pretty much be able to follow along, but you're going to have a lot of extra reading to do, but never hurts. It's only 20 pages long, so, if you're interested, check it out. Anyway, so let's just do a little recap. October 19th, we've got a court document coming out saying Heritage was changing our grades and attendance. And then November 1st, Heritage shuts its doors and says they ran out of cash. These two things just don't add up for me. If they add up for you, maybe you could explain to me how they add up, because I'm just not seeing it. I'm not seeing it, and a lot of people are not seeing it. And it's just, now they're filing this bankruptcy, and it's affecting a lot of people, and it's affected, I went to school in 2011 myself, went to Heritage in 2011, and to find out that, they were changing our grades and attendance in the first place is kind of disturbing. I mean, it's more than kind of disturbing. I just would prefer not to use profanities right here on the YouTube, right? So, with the information that we've just absorbed, and I hope that you would go back and take another look at that first video trying to explain to you how to discharge your loans, if that should be what you choose to do. I mean, if you want to take your credits and try to transfer them to another accredited institution, that is your decision. Go you, do what you do. But for those of us who don't want to simply transfer credits, there's a lot to this that I think we all should take a look at. And I'd like to, point out that Title IV funding, from what I understand, is the taxpayers' money. So whether or not you actually attended Heritage College, this still affects you, because they were changing our grades and attendance to keep the Title IV funding that should have been refunded. It's just crazy. $32.8 million of Title IV funds, taxpayers' money. This affects the whole country, and I don't understand why more people aren't upset about this or still throwing a fit. When you hear, ITT Tech shuts down, you're like, man, that sucks. That really sucks. That would suck if my college shut down. And then, lo and behold, your college shuts down, but they leave a note on the door that says they didn't do anything wrong. They just kind of ran out of cash, and makes your whole experience at the institution make a whole lot more sense once you're reading these court documents. This is a problem. And I'd like to discuss that more in detail, but that's a whole other video. So I hope that this video helped you wrap your mind around what has happened and is continuing to happen. I'm doing my best, and good luck to you all. Take care.